Hi friends, my name is Alena Shautsova. I'm an immigration attorney from New York. In today's video, we will be talking about VAWA, or Violence Against Women Act. And I will focus on this video on the most important aspect of the VAWA process, self-petitioning process for a green card. Thank you very much for joining. If this is your first time, welcome. I am Alena Shautsova, immigration practitioner, attorney, licensed lawyer from the United States. On my channel, I share tips, immigration news, and my thoughts on how to be successful with the immigration process in the United States, what news to be aware of, how to use laws of the United States in your favor, to do everything the right way, to do everything legally, and get your green card. Please join me, like and share this video. Do not forget to sign up for my channel, and let's start. VAWA, Violence Against Women Act, provides an opportunity for an abused non-immigrant to self-petition for a green card in the United States. Most commonly, VAWA will be used by a spouse, male or female, though the name of the law suggests that should be used only by females. It's not the case, and males also may use VAWA to self-petition themselves. It's very easy to qualify for VAWA if you meet certain qualifications. You will have to prove, number one, that you had a real marriage or you have a real marriage. That's right, you do not have to be divorced to use VAWA. And number two, you have to show that during the time that you resided with your spouse, you were subjected to cruelty and abuse. That's it. However, someone who is in the United States with prior immigration history may face some bars. For example, if previously you had unsuccessful attempt to get marriage-based green card, you may be subject to prohibition on self-petition 204C bar in your record. Sometimes you would file for your VAWA a little bit too late after the divorce. So as I mentioned, you can file for VAWA during a marriage or after divorce, but there have to be only 2 years, no more, passed after your divorce was finalized to be able to qualify for VAWA in the form of I-360 self-petition. But what other issues may arise when you are filing for VAWA? Another very common issue may be that you had previous attempts, successful ones, to come to the United States. And as such, you're subject to something called permanent bar. In this situation, your VAWA petition as a petition for deferred action in connection with the special protection may be approved, but green card, which is the second part of the process, may not be approved unless you qualify for a special waiver in connection with abuse, which is available only to VAWA petitioners when they're facing a permanent bar. Let's talk about evidence. What evidence do you need to submit in connection with your VAWA case? Number one, as I stated, you have to prove that you had legal marriage. It means that along with your marriage certificate, you have to submit proof that all previous marriages were legally terminated prior to you marrying a spouse who was abusive. Very important. Number two, you have to show that you resided with your spouse in the United States at least for a short period of time, on and off. In other words, if you had a rocky relationship and you would change addresses or you would be kicked out of your house, you still have to show that at least at some point in time, at least for a short time, you guys did reside together in the United States. Number three, you have to show that the marriage was a real marriage. In other words, it's not enough just to produce a marriage certificate. You have to show that you guys shared life together, even for a short period of time. You filed taxes together, preferably, or you had common bills, utility bills, you had a lease. At least show that you had photos together. Maybe you traveled together. Sometimes you will have to rely on your own affidavit and affidavits from friends and family who will confirm that you guys had that real relationship. Of course, other evidence such as social media posts or insurance policies or evidence of purchasing significant items together also can be used to prove that you had a real marriage. And the best evidence out of all of them would be a birth certificate of a child born in that marriage. Second group of evidence would include evidence of abuse. The abuse does not have to be physical when you are getting beaten up. It can be emotional abuse. The most important evidence here would be your detailed declaration made under penalties for perjury and or your affidavit. So this document, perhaps one most important evidence that you're going to use to prove that you were abused. Of course, also, you can show pictures of physical abuse if you had that happen to you, unfortunately. Police reports would be extremely helpful. Also, reports from human rights organizations or organizations that deal with domestic violence. Sometimes, if you're kicked out of your house, you're going to seek shelter. You're going to seek help from the government. So please preserve those documents, emails, because they will be extremely helpful for you when you're trying to prove that you were abused during the relationship. Finally, you have to show that you are a person of good moral character. You will have to produce an FBI self background check or background check from every state and country where you resided within the past 3 years prior to your VAWA application. It's very important to produce that evidence, and if the evidence is produced in a language other than English, it must be accompanied, just like any document for the United States Immigration, accompanied by a certified English translation. Not difficult to obtain that, guys. You don't have to hire a special company for that. Anyone, literally anyone, with a sufficient knowledge of your native language or the language of the document in English may sign that certification. Now, the process is quite lengthy. It may take 2.5 years before you receive answer on your I-360 petition. And typically, if you're filing for adjustment of status at the same time, you're not going to receive decision on your adjustment of status application at the same time when you receive decision on your I-360 form. First, I-360 form is going to be approved. This is the ground for your VAWA green card. And then I-45 form, the actual green card, will be hopefully approved. If you're filing for I-45 together, do not be alarmed that, again, the grant for I-45 is not issued simultaneously with approval for I-360 form. As soon as I-360 form is approved, and very often prior to that, you're going to receive C-31 employment authorization and deferred action, protection from removal. Very, very important. After that, you will have to wait if you can adjust your status for your green card. Remember that to receive a green card in the United States currently, you have to comply with all vaccination requirements, which is also true for those who are filing for green card based on VAWA. As such, you will have to show that you have COVID vaccines. That's typically number one issue when people are waiting for their green cards, that the government would like them to produce updated medical exam results proving that they have complied with all vaccination requirements. Once you receive that VAWA green card, after some time, you will be eligible for naturalization based on 3-year waiting period, not 5 years, but 3-year waiting period, expedited ground for naturalization. I know this video is packed with useful information for those of you who are considering or are going through VAWA process. Please rewatch it, ask me questions under this video, comment. Thank you very much for watching. Do not forget to like and share this video, sign up for my channel, and I hope to see you soon.